In disciplinary cases, document the behavior or conduct that must change. Be sure to include a timeline for them, such as the word immediately. Now, discrimination can be an issue in the hiring process too. Just asking a job applicant a seemingly innocent question like, can you work Sundays? Are you planning a family? What's your date of birth? Have been considered discriminatory in the courts. Again, good documentation can help, but it has to be consistent. Be sure all interview questions are standardized and meet legal requirements. And if medical evaluations are required for the job, they should be required for everyone, not just those suspected of a disability. To wrap up this discussion on controlling employment practice liability, let's get to the bottom line. Here are some of the things the lawyers who sue you are going to be looking for. Inconsistent discipline, undocumented or poor communication of policies and rules, unequal treatment such as work assignments and benefits, any discriminatory comments, undocumented training such as undocumented safety training, discrimination against or dismissal of employees for whistleblowing, filing workers' comp claims, or reporting incidents of discrimination and harassment. Now, did you hear all the D's of employment liabilities over and over? As a public official, if you keep those in your mind, they should keep you out of here. Shouldn't public officials be able to keep pornographic bookstores and adult entertainment businesses out of their districts? And shouldn't they be able to control commercial development in their areas? Wouldn't you agree that citizens should be able to decide whether or not a group home can be put in their neighborhood? Every day around the country, public officials confront zoning and land use issues like these, making what they truly believe are the correct decisions, and then ending up in court. Having their decisions cost thousands and all too often millions of dollars. Learning how public officials can control their liability in zoning and land use cases is what we'll be discussing in this section. Let's review the most common reasons public officials are sued for land use violation claims. Public officials are alleged to have not provided a fair and unbiased hearing and/or judgment known as due process. They are accused of targeting single projects or individuals with restrictive requirements. They ignore their own policies and criteria for making zoning and land use decisions. Now, if these claims can be proven, then public officials could be sued for violating federal laws, like the Fair Housing Act, or for violating the property owner's civil or constitutional rights. With zoning and land use issues, there's often a variety of judgments or decisions that public officials may be involved in. These include things like granting building and conditional use permits, modifying those permits, and building inspections. Generally, making these decisions should be done much like a judge in a courtroom would. They should be based on points of fact and follow existing land use regulations. In fact, these types of decisions are often referred to as quasi-judiciary or adjudicatory, or in other words, judge-like. Liability problems can start by not handling these decisions the right way. For example, if a public official is on the record in the news or speaking about how they will never allow certain businesses or commercial projects to open, they are no longer unbiased. They cannot be considered impartial when it comes to making a decision on the issue. And sometimes that's okay. If the only type of decision they have to make is a legislative decision, they may not be liable in a lawsuit. But other times, it's not okay. By taking a stand publicly before deciding a case, a public official could be accused of not providing a process that is fair and unbiased, that is legally due to citizens. They are denying due process, and they are creating a liability. You don't even have to take a public position to be liable in court. Discussions that public officials thought were private have been legally ruled to be discoverable. These discoverable conversations, whether in or out of meetings, or even with governmental attorneys, can be used as convicting testimony. Public officials need to carefully consider not only what they say publicly about zoning and land use cases, but also what they say in private, too. The second common type of land use lawsuits is what's known as targeting. This is where zoning ordinances are specifically targeted to one piece of property. The result can be expensive. For example, let's say that an organization wants to open a group home and the neighborhood residents oppose it. The residents get their board or council to pass a law restricting group homes in this neighborhood. The group house owners sue the public officials responsible, eventually winning in federal court. The public officials end up paying a big settlement that includes attorney's fees, compensatory and punitive damages, and the group house goes in anyway. The third common type of zoning and land use liability occurs when public officials ignore or fail to follow their own established procedures and decision-making criteria. Now, using the same group home example, let's say that the local Planning and Zoning Board, using objective information and evidence from the hearing, approves the group home. Then the neighborhood residents successfully pressure public officials to overrule the decision. The group homeowners sue. The case goes to federal court, and we all know how it ends for the public official. It ends badly. As a result, the governmental insurance company might pay the settlement and then raise their premium. Or the insurance company could deny the claim, citing the malicious or intentional acts clause in their policy. Then the public officials themselves might have to pay the settlement. So how can public officials avoid such cases? By using the 3 Ds to control land use liabilities: documentation, disclosure, and disqualification. Let's start with documentation. When a judge makes a decision, they document their reasoning. They back it up with facts and figures from their own and previous cases. Public officials should do the same. Document the reasons for your decisions, particularly if it's a controversial case. Be sure to use facts such as zoning or planning board decisions and analysis, not personal opinions. Then protect yourself by having your documented reasons included in the record for the case. Another way to protect yourself is disclosure. If contact is allowed, it may be a good idea to disclose any contact you've had with supporters or opponents. Keeping a record of phone calls, meetings, and discussions you've had with them could protect a public official against liability charges. Sometimes, though, you may just have to walk away. Sometimes you may have to disqualify yourself from a particular land use case. If you, a relative, a friend, or a business associate have a personal or financial interest in a case, it may be wisest to disqualify or recuse yourself from that case. Obviously, determining what to do has to be done on a case-by-case basis and could be confusing at times. If you're not sure about how to handle a decision about disqualification, disclosure, or documentation, review your entity's criteria or talk with your governmental entity's lawyer, solicitor, or insurance professional. However, public officials' liabilities in zoning and land use cases can be easily reduced following some of the guidelines we've discussed. Remember that people involved in land use cases have a right to a fair, unbiased hearing and judgment of their proposals. This process could be broadly defined as due process. If it's a controversial issue, you can't take sides and then decide. You may have to disqualify or recuse yourself from the case. Don't get involved with enacting or passing ordinances or rules that target one case. Instead, stick to your existing decision-making criteria. It should be documented, applied consistently, and periodically reviewed by legal counsel. Don't forget that anything you say anytime to anybody might end up in court as testimony. Avoid saying things that could lead to losing a lawsuit or even a conviction.